This morning, the Supreme Court has delivered a monumental victory for the Constitution, the separation of powers, and the rule of law in striking down the excessive use of nationwide injunctions to interfere with the normal functioning of the executive branch. The Supreme Court has stopped the presidency itself. That's what they've done. And really, it's been an amazing period of time this last hour. There are people elated all over the country. I've seen such happiness and spirit. Sometimes you don't see that, but this case is very important. I was elected on a historic mandate, but in recent months we've seen a handful of radical left judges effectively try to overrule the rightful powers of the president to stop the American people from getting the policies that they voted for in record numbers.
The Supreme Court's emergency docket, also called the shadow docket or the interim docket, is for, well, emergencies. This is every time the federal government had a case there, back to the first Trump administration. And here's just 8 months into his second term. It's being used in record numbers.
Emergency applications used to be a very, very small and not especially divisive part of the Supreme Court's work. Now, this is the front lines.
Not only are there more of these cases, but President Trump is winning more than his predecessors have. And we don't really know why.
We don't know why, because with this shadowy process, the Supreme Court doesn't have to.
The Supreme Court just handed Trump the most dangerous ruling of his political life. Not because it went against him. Because it went against him and he said no. Let that land for a second. The highest court in the United States, the institution whose rulings are the final word on what the law means in this country, issued a direct, specific, enforceable order on immigration enforcement.
President Trump really dislikes these judges.
The Ninth Circuit is a disaster. Nobody can believe these decisions we're getting from the Ninth Circuit. It's a disgrace. The Ninth Circuit, everybody knows it. It's totally out of control.
When Trump took office, most of the Ninth Circuit's judges had been appointed by Democratic presidents, and they overruled some of Trump's most provocative executive orders. The travel ban, emergency funding for a border wall, they all stopped here.
Very hard to win at the Ninth Circuit, if not impossible.
A big win for President Trump today as the Supreme Court denies Democrats access to grand jury material from Robert Mueller's Russia investigation, at least for now anyway. The court agreed to hear the administration's appeal of a lower court ruling that the documents be turned over to the House, which likely would not happen until after the 2020 election. House Judiciary Committee Chairman Jerry Nadler putting out this statement saying that he is confident Democrats will.
And the President of the United States looked at it and publicly refused to comply. That is not spin. That is not characterization. That is the documented sequence of events as they occurred. Order issued. Compliance refused. Constitutional crisis triggered. And right now, as you are watching this, H. Resmer 353 is sitting in the House Judiciary Committee. Impeachment articles are filed. The third impeachment of Donald Trump is not a threat. It is a live proceeding. And this time, the constitutional foundation is cleaner than anything Congress has tried before. Here is what actually happened and why it matters more than anything else in Trump's legal story. The immigration litigation that produced the Supreme Court order was not a close legal call. Courts at multiple levels, district courts, appellate courts, now the Supreme Court, examined the same policies and reached the same conclusion. Mass deportations without proper hearings, denials of asylum claims without the process the law requires, detentions without bond, all of it violating federal immigration law and constitutional due process. Trump appealed every single ruling. He fought every injunction through every available procedural vehicle. He took it all the way to the top, and the Supreme Court sided with the lower courts. The order the court issued was specific, not vague, not aspirational, not subject to interpretation. Reinstate legal protections for asylum seekers. Stop deporting people without giving them the hearings they are legally owed. Make real efforts to bring back the individuals who were removed in violation of their legal rights, people who had valid claims, who had pending proceedings, who should never have been on those planes. That is what the highest court in the land ordered. And Trump said no. His legal justification is that immigration enforcement is an inherently executive function, and that the president has unlimited discretion in how to exercise it. That argument is wrong as a matter of constitutional law. in a way that is not complicated to explain. Yes, presidents have prosecutorial discretion, the ability to prioritize which cases to pursue and which to deprioritize. What presidents do not have is the discretion to ignore laws that Congress passed or to defy court orders interpreting those laws. The moment a president claims the authority to decide unilaterally which court orders he will follow and which he will not, he is not exercising discretion. He is claiming to be above the law. And that is a claim the constitutional framework was specifically designed to prevent from going unchallenged. The people bearing the real cost of this defiance are not abstractions. They are the individuals who had valid asylum claims, who were in active legal proceedings, who had protections under the law, and who were put on planes and removed before those proceedings could conclude. Some of those people went back to the countries they were fleeing. Some are impossible to locate now. The Supreme Court ordered the administration to make real efforts to bring them back. The administration's response is that it cannot or will not do so. The irreversible harm those individuals have suffered as a result of deportations the courts have ruled illegal is the human consequence of what the political commentary frames as a constitutional dispute. Now, let us talk about H.Res. 353, because this impeachment proceeding is constitutionally different from the two that came before it in ways that matter for the political arithmetic. The first impeachment, Ukraine, abuse of power and obstruction of Congress, produced a Senate acquittal in part because Republicans could argue, credibly to their base, that the underlying facts were disputed and that the conduct, however troubling, did not clearly meet the constitutional standard for removal. The second impeachment, January 6th, incitement of insurrection, produced 57 conviction votes, 7 Republican senators crossing, still short of 67. Republicans who voted against conviction could point to First Amendment arguments, to the fact that Trump had left office, to procedural objections about the timing of the proceeding. This impeachment has none of those escape routes available. The Supreme Court issued an order. The order is documented, public, specific. The administration's refusal to comply is documented, public, explicit. There are no disputed facts about what happened. There is no ambiguous timeline to parse. There is no competing interpretation of the evidence that requires sustained legal analysis to evaluate. The sequence is clean. Order issued. Compliance refused. Every Republican senator who votes against conviction will be voting to affirm the proposition that a president can openly defy a direct Supreme Court order without facing the constitutional consequence the founders built specifically for this situation. That vote, in favor of unlimited presidential authority to ignore the Supreme Court, is a vote that will define every one of those senators for the rest of their political careers. It is a vote that will be cited in every future campaign against them. It is a vote that future presidents of both parties will point to as the precedent that permits them to treat court orders as optional. The political cost of that vote is higher than any vote cast on either of the two prior Trump impeachments, because the factual simplicity of the current defiance eliminates every escape route that prior impeachments provided. The enforcement problem that makes congressional action necessary is the one element of this story that gets underweighted in the political commentary. The Supreme Court has no army. It has no enforcement mechanism that operates independently of the executive branch's cooperation. Courts issue orders. The execution of those orders depends on the executive branch respecting judicial authority as a foundational principle of constitutional governance. When the executive branch refuses, the court cannot physically compel compliance. What it can do is create the documented record of defiance that the other branch, Congress, is constitutionally authorized to act upon through the impeachment and removal mechanism, H-Reses. 353, introduced by Representative Shri Thanadar, is that congressional action being initiated. The resolution details the specific conduct, the Supreme Court order, the documented refusal to comply, the pattern of treating judicial authority as optional, and argues that conduct constitutes the high crimes and misdemeanors that Article 2, Section 4 identifies as grounds for removal. The resolution is before the House Judiciary Committee. The committee process, hearings, testimony, votes, is the constitutional mechanism for building the formal record that a House floor vote on impeachment requires. The political arithmetic in the House is straightforward. Democrats control the chamber. A simple majority impeaches. The question, as it has been in both prior impeachments, is the Senate. 17 Republican senators would need to join the full Democratic caucus to reach the two-thirds threshold for conviction and removal. The documented high-water mark is 7, the senators who voted to convict on the January 6th impeachment. The gap from 7 to 17 is 10 additional Republican senators making a different calculation than they made in February of 2021. What has changed since February of 2021 is the factual record that senators voting on this impeachment will be voting on. The prior conviction vote required senators to assess what Trump's speech on January 6th caused, and whether that causation met the constitutional standard. Reasonable senators could reach different conclusions about that assessment. The current situation requires senators to assess whether an open, documented public refusal to comply with a direct Supreme Court order constitutes the conduct that impeachment is designed to address. That assessment has a much narrower range of reasonable conclusions. The senators in competitive states, the ones whose 2026 general election calculus includes meaningful numbers of voters who voted for Trump in 2024 but who have shown movement in their support, are the ones doing the most urgent calculation right now. A senator in a state where the general election margin is tight, where independent voters make the difference, where the political environment has shifted toward accountability, faces a different version of that calculation than a senator in a safe Republican state where the primary is the only relevant electoral constraint. The Andrew Jackson parallel is the historical reference point that puts the current moment in its sharpest context. Worcester versus Georgia, 1832, the Supreme Court ruled that Georgia could not enforce its laws on Cherokee territory. Jackson refused to enforce the ruling. The Trail of Tears followed, the forced removal of the Cherokee people, a march that killed thousands, one of the most catastrophic exercises of unchecked executive power in American history. Historians have consistently assessed Jackson's defiance as the moment when presidential disregard for judicial authority produced irreversible human catastrophe. The people who were deported in violation of their legal rights, removed before their proceedings could conclude, sent to countries they were fleeing, some now impossible to locate, are the current human consequence of the same dynamic. A president deciding that his policy preferences override the judicial authority the Constitution established to check exactly that kind of executive overreach. Congress in 1832 did not have the opportunity to hold Jackson accountable through the impeachment mechanism in a way that produced removal. Congress in 2026 does have that opportunity. Whether it exercises it, whether enough senators conclude that the factual clarity of this defiance finally justifies the political cost of crossing, is the live institutional question that the H. Resern 353 proceeding has put before the legislative branch in the most direct form available under the constitutional framework. The question is not whether Trump defied the Supreme Court. That is documented. The question is whether the institution the Constitution gave the authority and the responsibility to respond to exactly this situation has the will to respond. That answer is being written right now in the House Judiciary Committee, in the conversations between Senate Republicans and their political advisors, in the public statements that members are or are not making about a president who told the Supreme Court that its orders are optional. Whatever the answer is, it will be on the record. And the record is what matters. Let me tell you what the record already shows. Because the H. Resern 353 proceeding does not exist in isolation. It exists in the context of a 2-year accountability record that has been building toward exactly this kind of institutional confrontation. The judicial pushback against the administration's immigration policies was not a surprise. It was the predictable outcome of an enforcement approach that courts across multiple jurisdictions repeatedly found to exceed the legal authority the executive branch holds under the Immigration and Nationality Act and under the constitutional due process protections that apply to people within the United States, regardless of their immigration status. The administration knew the legal constraints existed. It knew courts were applying them. It chose to test those constraints at every level rather than to operate within them. That choice, to push enforcement to the limits of what courts would allow, to appeal every adverse ruling, to use the delay mechanisms available in appellate litigation to continue enforcement while the legal challenges worked their way through the system, is the strategic posture that eventually reached the Supreme Court. And when the Supreme Court resolved the final available legal question against the administration's position, The choice that remained was whether to comply or to refuse. The refusal is what produced H-Res 353, not the underlying policy dispute, not the disagreement about immigration enforcement priorities. The specific, documented public refusal to comply with a direct Supreme Court order. That is the constitutional event the resolution responds to, and it is an event with no ambiguity in its factual record. The people who were deported before their proceedings concluded deserve more than a passing reference in an analysis of constitutional mechanics. They are the reason the legal challenge to these deportations exists. They are the reason courts at multiple levels found the administration's conduct to be unlawful, and they are the reason the Supreme Court ordered the administration to make real efforts to bring them back. Some of those people went to El Salvador's CICOT facility, the maximum security prison whose conditions human rights organizations have documented extensively. Some went to countries from which they had fled persecution. Some are in circumstances where returning them, if the administration were to comply with the court order, would require diplomatic engagement with governments that may not cooperate. The practical difficulty of undoing illegal deportations does not reduce the illegality of the deportations themselves. It is, if anything, the most powerful argument for why courts and Congress take the enforcement of due process protections seriously, because the harm from violating them is often irreversible. The constitutional architecture that H-Res 353 invokes was designed by people who had just spent years fighting a war against a government that claimed the authority to do whatever it wanted regardless of legal constraints. The founders were not abstract theorists about executive power. They were practitioners who understood from direct experience what unchecked executive authority produced and who built a specific set of institutional mechanisms to prevent it. The impeachment power is the most powerful of those mechanisms. It requires the legislative branch to make a formal institutional judgment about whether the executive's conduct crosses the line the Constitution draws, and to act on that judgment through the most consequential available procedure. That procedure, formal articles of impeachment, committee hearings, full House vote, Senate trial, is deliberately demanding. It is not designed to be easy. The founders wanted it to be hard enough that Congress would not invoke it for ordinary policy disagreements, but available enough that genuine constitutional violations could be addressed by the institution they trusted most to make that judgment. The elected legislative branch, accountable directly to the people in every congressional election cycle. H-Res 353 puts that judgment before Congress in the clearest available factual context: a Supreme Court order, a documented refusal to comply, and a constitutional framework that identifies exactly this kind of executive defiance as the conduct impeachment is designed to address. The senators who will vote on whether to convict and remove know all of this. They know the constitutional framework. They know the factual record. They know what their votes will mean for the institutional precedent they are setting. The question that determines the outcome is whether enough of them conclude that the factual clarity of this defiance, combined with the political environment in which they are casting their votes, makes the crossing worth the cost. 17 Republican senators. That is the number. It is not an impossible number. It is 10 more than the 7 who crossed on the January 6th conviction vote, in a factual context that is considerably less ambiguous than the incitement question those 7 were voting on. Whether those additional 10 senators exist and are willing to cast that vote is the live institutional question at the center of this proceeding. The political environment is moving. The accountability record is extensive. The factual foundation of this impeachment is cleaner than anything Congress has tried before. And the constitutional stakes, whether a president can openly defy a Supreme Court order without facing the remedy the Constitution provides, are as high as they get in the American institutional framework. The record will show what Congress decided. History will assess whether that decision was adequate to the moment it faced. And here is the thing about that historical assessment that I want you to carry with you. The senators voting on this impeachment are not voting in a vacuum. They are voting with full knowledge of what happened to the senators who voted against conviction in the first 2 Trump impeachments. The senators who chose party loyalty over the constitutional judgment those proceedings required, many of whom are still serving, all of whom now face a 3rd impeachment vote in a factual context that eliminates every defense they used before. The senators who voted against conviction on the Ukraine impeachment could argue the facts were disputed. The senators who voted against conviction on the January 6th impeachment could argue the causation standard was unclear. The senators who vote against conviction on this impeachment have no argument available except that presidents can defy Supreme Court orders. That is a position with no constitutional support, no historical precedent, and no political viability with the voters they need to keep their seats. 17 senators. The constitutional mechanism is designed and available. The factual record is unambiguous. The political cost of voting against conviction in this specific context is higher than it has ever been on a Trump impeachment vote. Whether those 17 senators exist and cast those votes is the question the proceeding will answer. The proceeding is moving. The documented record is already assembled. And every day the administration refuses to comply with the Supreme Court's order is another day of material that strengthens the case that the conduct at issue is exactly what H. Resern 353 says it is. Every additional day of defiance is another day the documented constitutional violation continues. The proceeding has begun. The record is being built in real time, and the constitutional question at the center of it, whether a president can tell the Supreme Court no and face no consequence, is going to be answered, one way or another, by the votes that follow. Watch this space. The answer is coming. And when it comes, when those votes are cast, when the Senate record is written, every American who watched this moment unfold will know whether the constitutional framework the founders built to address exactly this situation was strong enough to hold when it was tested by a president who decided the Supreme Court's orders were optional. That is the constitutional test. It is happening now, in real time, with stakes that extend far beyond this president and this Congress to every president and every Congress that follows. Subscribe to Daily News. No spin, no corporate filter, just the documented record, delivered straight, every day. Stay with us.